Welcome viewers to Kanooni CHARCHA YouTube channel. Today's topic is bail, not jail. This doctrine was propounded by Justice V R Krishna Iyer in case Kanti Narasimhulu versus Public Prosecutor. Justice Iyer, V R Iyer, you are knowing, was a Supreme Court Justice, Judge. While deciding this case, he has propounded that bail should be a rule and jail should be exception. It is being followed afterwards by the law courts. This is based on, you are knowing that in the administration of criminal justice, or you may say the criminal jurisprudence demands that demands or otherwise proposes an accused innocent till his guilt is proved in due course of trial before a competent court. On this theory, but we have noted now the jails are overcrowded. The bails are not being granted even in this magistrate trial cases. This is not my observation, this is observation of yesterday's case of Their Lordships while granting a bail. Earlier, the bail was refused by the trial court as well as by the High Court. Many attempt was made by this accused for habeas. Successive application was dismissed by the Honorable High Court. Matter was of cheating, for alleged fraud, and further. This I will go to the case. Now I again come to this 69% the data of 2019 related to the prisoners. The under trial prisoner, not under trial, I may correct myself, the pre-trial prisoner, whose trial has not yet begun. The case today we will discuss of the Supreme Court. It is also the same case. Charges were not framed. This consideration was also looked by this Honorable Supreme Court of India in the case. I will discuss that case afterwards. 69% people are those in jail whose trial had not yet begun. It may be in investigation stage. You are knowing that conditions of our jails, inhumans. You may touch health or otherwise. I will not go in this conditions of the jail. You are knowing, viewers knowing about the India's jails. Now, question was before the Supreme Court of India. They were deciding a case, but not case, but a bail application. The appellant, when his bail was rejected by the Honorable High Court of Gujrat many times, he approached the Supreme Court of India. The title of the case, this bail application is Abdul Majid, Abdul Sattar, Memon versus State of Gujrat. The offences for which FIR was lodged against him are Section 406, 419, 465, 467 and 471 IPC. It appears that a mutation was forged or otherwise made, and complainant appears to be his father. Complainant appears to be father of the accused, who has lost the allegation was he has got a mutation unauthorized, increased by way of a mutation, and made a illegal unauthorized state. But it appears, but he is referred as a habitual offender when this bail application was contested by the state council referred in the bail. But the Supreme Court of India, while dealing with this application, observed that out of 14 cases lost against him, charge sheets, this 9 had been already quashed. Now I will go, I have referred the facts. The main observation ground the High Court has not appreciated earlier about this, that case is a magistrate trial, and the Supreme Court of India, while dealing with this case, this bail application, I will read out this. Justice Abhay and Justice Augustine George Masih, these two bench was of these two judges. But they have observed after 22nd of November 2023, there is no progress in the trial. Even charge had not been framed. This is observation of the Supreme Court while dealing with the this application. Antecedents of the appellants are pressed into server. Out of 14 cases, we find that in 9 cases either he has been acquitted or offence has been quashed. This I have earlier told you verbally. It is not in dispute that the case is a magistrate trial. In our view, the High Court ought to have granted bail. Accordingly, the appeal is allowed. This is a crux. Well, thus now there is a certain remarks verbally made by with regard to the topic I have chosen, bail not jail. But during the hearing, the advocate for the appellant submitted that this is the proceedings what the appellant's advocate has asserted before the Supreme Court of India in this while the hearing of the case, that all the co-accused had been granted bail and that the appellant had been in custody for a period more than 1 year. Justice Oka, this remarked. This is a remark verbally made. It is a magistrate trial case. How can he remain in custody? This is observation in the during the hearing made by this honorable justice. The counsel for the state. Now, I have already referred verbally that counsel for the state of Gujrat responded, he is actual offender. I have referred earlier. He will come out and do it again. All offences against him are cheating. This is what forgery and fraud. However, Justice Oka noted that while denying bail, the Gujrat High Court had not individually examined the FIR cited by prosecution as antecedents. Generally, what while granting bail, 3-4 things are gravity of offence, severity of punishment provided, and chances of the accused tampering with the prosecution evidence or other or threatening or this putting in danger to the life of the witnesses. This is I will read out further. The court noted that appellant had been in custody for over a year, and 3 months. Now he is in custody from the last 1 year and 3 months. This is noted by the Honorable Supreme Court. On November 2022, 23rd, 23, mean now 22nd of November 23, the special leave petition filed by the appellant against the order rejecting bail was not entertained by the Supreme Court, with the observation that no case was made out for granting bail at that stage. It means Supreme Court has already not granted bail. However, there has been no progress in the trial. Now, circumstances have been changed. This court, their lordship have observed that there is no progress in trial since then. New circumstances arise. The remaining in jail where there is a refusal or not grant of bail should not result into having punishment to the accused. This is also the custody of this accused shall not be as if it is a punishment to him. This is also be taken into consideration. I think the making of such a reference is like on this theory. The Supreme Court allowed the appeal and ordered the appellant be produced before the trial court within 1 week. The trial court was directed to release the appellant on bail on appropriate terms and conditions. In case order is made, the trial court is ordered that you may put the conditions which are generally put, and those are referred earlier also in the non-available cases where and now you will find those conditions which are generally made in a bail order. So accordingly, I think this direction has been made to the trial. According to the FIR, now they are. I have verbally already referred here. What were these allegations? But the allegations now will already repeat by reading this further. According to the FIR, the complainant discovered on the trial invitation interest. I have already referred regarding the lifting of charge over his land, unless the appellant who is complainant side, in case accused here who is seeking bail is the son of the complainant. There is a I think a land dispute, property dispute between father and son in the present matter, and had orchestrated the sale of the land using forged document. This is allegation that made by the complainant, who is the father of the appellant. The sale deed was executed in another person's name, and this is the allegation. The appellant was arrested on 4th of May 2023. So now more than 1 year they have calculated the period and had remained in custody since then. This now there is also reference of High Court's order, but High Court has how High Court has made the order while refusing the bail. The High Court had previously rejected the appellant's bail, noting the appellant's numerous antecedents. I have already made, which include a case of cheating, producing fraudulent documents. This is all with regard to. So now a comment was made that by the lordships, the remarks you may say generally made when hearing of this case was, the High Court and trial court seems to have forgotten that bail is not to be withheld as punishment. This is also in many judgments you will. I have already referred that the custody, the remaining when the refusal of the bail should not result into punishment of accused without a formal trial. You may say, the trial court and High Court try to play safe in bail matters, have forgotten bail is the rule, and this is what I have said earlier. This I will again come to the theory, the doctrine propounded by His Lordship, this V R Krishna Iyer. In Judgement, I have already referred that bail is the rule, and jail is the exception. This is in case Rtd Kanti. I have already referred. Now I will say that bail can be withheld, can be accused if it is in public interest. This individual interest and this interest of society is to be weighed. If interest of individual interest is overweighed the societal interest, then bail is to be granted. And if this societal interest prevails upon the individual interest, mean then bail may be refused. This is not, but this discretion, the magistrate, judge, whosoever is dealing with this bail application, must be judicial discretion. He must see both the sides. This whether his remaining in jail is in the interest of justice, and or his release, a which is, you may say, Article 21 of Constitution of India. Article 21 talks about personal liberty. This Constitution provides fundamental right which provides personal liberty. If some has to be taken, it is taken in due course of law, which has propounded in Menka Kanti's case. Not they must be fair. If somebody is to be kept in jail, his bail is to be reported. All these rights of the accused is to be paid, to be looked into, to be taken into consideration on the merits of a particular case. I think this is sufficient for today, and I will again come before you with the new topic, new episode. Thank you.